И 2007 года
Моих детей забрали родственники со стороны отца и бывший муж, и укрывают от них уже на протяжении 2 лет.
Я сама исполнила решение при первой представившейся мне возможности, просто бежав с ребенком на руках из здания службы судебных приставов.
Они не нужны на самом-то деле. Это является либо инструментом мести, либо манипуляцией, лишь бы дети были с кем угодно, только не с мамой.
До тех пор, пока не будут накладываться аресты, не будет уголовной ответственности на должников, родительский киднеппинг, он просто будет процветать, что, в общем-то, и происходит сейчас.
Ни органы опеки, ни ПДН, ни уполномоченные по правам ребенка, никто ничего не может сделать.
Просто сидізал бехандош, там лирол шерсо, там сидізал бехандош, уадалул тол шерсо. Просто ива сумбангацевич, харцумаите.
И до сих пор, кроме как на себя, мне надеяться не на что, несмотря на то, что я живу в правовом государстве.
Hello, my name is Grigor Avdisyan. I'm Advocacy Director for Stichting Justice Initiative based in Moscow. I will address implementation in the Khanamirova versus Russia group. What is this group of cases about? Most cases in this group concern the violation of the applicant's right to family life due to non-enforcement of domestic court decision granting them custody over their children. Despite the need for urgent individual measures, in 4 recently decided cases, the Khanamirova group has not been on the committee's agenda since end 2014. We anticipate that the number of cases in this group will continue to grow until systemic legal shortcomings are remedied, which means there's a need for general measures also. A few words about context of these cases. The non-enforcement of custody decisions is due first to systemic legal shortcomings, such as the lack of significantly serious measures under Russian law to induce compliance with custody decisions. Second, the lack of sanctions in law and practice for so-called family abduction, where a child is kidnapped by a relative. In the North Caucasus region, gender discriminatory practices compound these existing legal loopholes. Because of local customary law, divorced women and widows are denied any role in their children's upbringing on a massive scale. And when cases go to court, judges and bailiffs routinely fail to effectively uphold mothers' right. Thus, cases in this group from the North Caucasus concern custody disputes not between 2 parents, but rather between the mother and the clan of the relatives of deceased or absent father. This is a much more serious violation of the Russian family code, which provides that a child's biological parents have priority in their upbringing. What are the court's decisions and conclusions in these cases? In cases requiring urgent individual measures, such as Muruzhova versus Russia, Yusupova, and Gubashova, the court established that the applicants had had no contact with their children for between 5-7 years, despite custody decisions in their favor. Examples of the shortcomings the court found in these cases are: first, it took the authorities on average between 5 months to a year to take basic measures for enforcement of the local court decision, such as establishing with bailiff's office, which bailiff's office had the responsibility for execution of the decision, sending documentation to the right office, establishing the child's whereabouts, etc. The bailiffs took no action to prepare the children for the return procedure decided by the court. Finally, the authorities didn't sanction the debtor for evading enforcement. The Zaliha Magomedova case is the most egregious example of systemic violations of applicants' right to family life. In this case, following the death of her husband in 2009, the husband's relatives kidnapped her six children and eventually succeeded to strip the applicant of her parents' right. The applicant has not seen her children for over 10 years. The European Court found that the domestic court decisions had been grossly unreasonable and arbitrary. These cases need urgent reaction. Why urgent? Well, first of all, the longer the time that goes by, the less likely it is for mother and the child to reestablish their relationship. Second, because children that have been abducted by their father's relatives are often being concealed, they are often absent from schools and don't go to doctors, sometimes endangering their health. Third, as our experience shows, unfortunately, children are more prone to neglect and violence when they live with neither parent, but with their paternal relatives. Furthermore, we have done research showing that forcible separation of mothers and children leads to lasting psychological harm. What is the current situation in these cases? Unfortunately, enforcement proceedings have not become more efficient since the entry into the force of the court's judgment. In Morozov's case, the authorities still neglect to sanction the debtor for his blatant non-cooperation under existing legal mechanism. If he had been sanctioned promptly and after each attempt at evasion, it would have been possible to launch a criminal case against him. In Yusupova, the authorities have not formally established the child's location, even though the applicant carried out her own independent investigation and established that her son was living with his father's relative in Chechnya. In Zaliha Magomedova case, a local court in Chechnya in July 2020 forged documents that had been submitted by the applicant's representative in order to refuse her request for a review of the decision, stripping her of her parental rights. We are currently appealing this refuse, but the trend is worrying. It shows the length to which the authorities will go to ensure the applicant's rights are not restored. What does execution look like in these cases? Well, we believe that the government must make a good faith effort to reunite the applicants with their children, which means, first, the opportunity to reestablish contact with them. In fact, in the past, the government has implemented several judgments from the group, which illustrates that where is the will, there is a way. For example, in two similar cases from 2011-2013, the applicants had their children returned to them just 6 months after the judgment. In the third case from 2013, a minimum number of the measures was taken in good faith, which allowed, however, the applicant to reestablish contact with her son. Our recommendations. Well, first of all, to ensure that Khanamirova group is monitored by the Committee of Ministers under the enhanced procedure. Second, the group needs to be put on the agenda, ideally for the December 2020 Committee of Ministers DH meeting. And the third, the group should be examined every 6 months in order to monitor urgent individual measures and discuss general measures too. A word about general measures. Actually, several years ago, in an earlier action plan, the government itself acknowledged that new legislation was indeed needed to address systemic issues in these cases, in particular revised legislation. And in January 2020, the Russian authorities announced their intention to introduce criminal liability for refusing to transfer a child under a court order. We consider this an important step towards recognizing that non-enforcement of is a systemic problem that must be remedied with a new legal mechanism. For more information, please go to the website dedicated to this issue of family kidnapping and the right to a family life in Russia. There you can read the stories of 16 of our applicants, see an analysis of the court's conclusions, read testimonies on psychological harm, and see our proposals to remedy the problem. You can also read our submission made in 2020 under Rule 9.2, which discusses individual and general measures in Khanamirova Group at length. Thank you for your attention.